Good morning. This is your Kelso Report for Friday, January 6th, and I'm your host, Clark Kelso. Well, today we have a couple of one-liners and a certified question to the California Supreme Court. We begin with criminal procedure. Under Penal Code Section 1237.5, a defendant who pleads guilty or nolo contendere generally may not appeal the felony conviction without obtaining a certificate of probable cause. But what happens when a defendant admits to a prior felony conviction pretrial, which is the basis for a possible sentence enhancement, pleads not guilty to the new charged offense, and then is convicted by a jury of the new offense? Does that defendant need a certificate of probable cause to appeal? Well, in People v. Maltzby, the Court of Appeal held that Section 1237.5 did apply. You needed the certificate. But the Supreme Court of California reversed that determination yesterday, concluding that Section 1237.5 referred only to appeals after guilty pleas, and that it therefore did not apply when the defendant pled not guilty but admitted prior convictions. When the defendant is convicted of an offense and a sentence enhancement is added based on a pretrial admission of prior convictions, the defendant can appeal without a certificate of probable cause. Now, in the case before the court, the defendant did not assert any error in the jury trial, but did assert that he was not given proper advisements before admitting to the prior convictions. The Supreme Court remanded the case to the Court of Appeals for further proceedings on the merits of the appeal. Next, we have an interesting search and seizure case. Now, when you have concealed illegal drugs in your groin area, and then you voluntarily consent to a pat-down search at an airport on your way to the gate, and you hold out your arms and spread your legs to facilitate the search, an outside-the-clothing pat-down that reveals 700 oxycodone pills hidden in the groin area does not exceed the reasonable bounds of your consent. That is the holding from the Ninth Circuit in United States v. Russell. Now, this seems like a slam dunk to me, but the panel indicated that this was an issue of first impression in the Ninth Circuit dealing with the scope of a voluntary consent to a search at an airport. So, for anyone who thought this was an open issue, consider the issue now closed. Finally, we have a certified question to the California Supreme Court in an insurance law case. In 1997, a flood of the Truckee River damaged a hydroelectric dam covered by a replacement cost insurance contract. The repair costs were higher because of the need to comply with certain building ordinances and laws which had changed since the original construction. The insurance policy contained an exclusion for increases in the loss due to any ordinance, law, or regulation affecting repair. Finding California cases in conflict on the proper interpretation of this type of exclusion, the Ninth Circuit in Sierra Pacific v. Hartford Steam Boiler certified two questions to the California Supreme Court. First, whether, under California insurance law, a building ordinance or law exclusion found in the perils exclusions section of a property insurance policy effectively excludes coverage for increased costs caused by complying with ordinances and regulations if the underlying loss was caused by a covered peril. Second, a related question, whether under California insurance law the costs of obtaining building permits or conducting required environmental impact studies are considered costs excluded by a building ordinance or law exclusion, or whether these costs are better considered as part of the replacement cost under the policy. Now, I have to say that even though there is a conflict in intermediate state appellate decisions on this issue, I doubt the California Supreme Court really thinks this is an issue that it would have itself granted review to resolve. But out of deference to the certification process, my guess is that the court will accept the certification and give us an answer in due course. And that's it for today's Kelso Report. Have a great day in the law.